What happens if a corporation's officer or director makes a contract to provide goods or services to the corporation? The court considered that question in Talbot v. James. Lula Talbot owned a parcel of land in Myrtle Beach. W.A. James approached Lula and her husband, C.N. Talbot, with a proposal to build an apartment complex on the parcel. After negotiations, the three of them contracted to form a corporation to build and operate an apartment complex. Lula would convey the land to the corporation, and James would oversee the project's planning, construction, regulatory approval, insurance, and financing. James would also make his personal credit available as necessary. In exchange, the Talbots would receive half the corporation's stock, and James would receive the other half. After James obtained architectural plans, Federal Housing Administration insurance commitments, and financing, James and the Talbots then formed Chicora Apartments Incorporated. James received 10 shares, and the Talbots split 10 shares. James was elected president, and C.N. Talbot was elected vice president. The directors then voted to borrow $850,000 from the lender. They also authorized James to contract with builders to build the complex. The next day, the corporation executed a construction contract with James Construction Company, a sole proprietorship owned by W.A. James. He signed the contract both as president of Chicora Apartments and for James Construction. James personally received about $25,000 from Chicora's lender. The Talbots later claimed that James didn't inform the Talbots that James was contracting with his own construction company. Construction proceeded, and the complex eventually opened. C.N. Talbot and a resident manager he hired managed the complex, received the rents, and paid the bills. 4 years later, an accountant advised James and Talbot that Chicora Apartments was in financial distress. The Talbots questioned James's disbursement of loan proceeds and sought to examine the corporate records. James refused them access until a circuit court judge ordered him to make the records available to the Talbots. The Talbots then sued James for an accounting. The court's master in chancery found that James, as president of Chicora Apartments, had made a contract with himself without disclosing his interest to the Talbots, but the trial judge reversed and entered judgment for James. The Talbots appealed to the South Carolina Supreme Court.